Yesterday, the Alberta Court of Appeal released its opinion on the constitutionality of the Federal Impact Assessment Act, which began life as Bill C-69. And the upshot of their decision is that the act and the regulations are unconstitutional. As you can imagine, that unleashed quite a storm of comment in the media and on social media. So I'm going to talk to Professor David Wright, the Faculty of Law at the University of Calgary, about it. Welcome to the interview, David.
Hi, Markham. Good to be here. Thanks.
Well, before we get into the nitty-gritty of what the justices actually said, two things. First one is Alberta Environment Minister Jason Nixon said publicly that the Federal Impact Assessment Act no longer applies in Alberta, but that seems to be a wrong take, correct?
Yeah, I mean, certainly to my knowledge and the knowledge of other legal experts that have that I've chatted with and that have weighed in, there's no legal basis for that comment or that extrapolation of the outcome from the court yesterday. As the federal minister said, the Impact Assessment Act continues to apply in Alberta. Today is the same as 2 days ago before the reference case came out. All that flows from the reality that this is not a typical binding court decision. This is a reference case where the government of Alberta asked the Alberta Court of Appeal for its legal opinion on the constitutionality of the act and its regulations. And so this is just an opinion. It's non-binding. Now, most governments usually take it very seriously as guidance, and there's something to that. And certainly there's a core behind the minister's statement yesterday along those lines. But it is just guidance. And really in this context where we're bound for the Supreme Court of Canada in any event, it's temporary guidance at most.
Well, I'm going to ask you a question that probably is more political than legal, but I'll ask it anyway. And that is, this seemed really odd to me, because if you make, BC and Alberta have been fighting about the application of this of jurisdiction over a Trans Mountain expansion pipeline for years now. And the courts have consistently upheld exclusive federal jurisdiction. So if Alberta says, oh, no, that jurisdiction now doesn't apply in BC, or in Alberta, then it seems to me that BC could just turn around and say, okay, fair game. It doesn't apply in BC. Let's tear up the TMX pipeline. And that seemed like it could come back to bite Alberta if the argument ever held up.
Yeah, and that's where the majority opinion yesterday is helpful in that way, in that they sort of point to there being two types or classes of projects in the project list. So these are the physical activities regulations. This is the regs colloquially referred to as the project list that identify the projects that may go under assessment by the federal government. And they basically said, look, this set of projects that are federally regulated, quite clearly the federal government has authority and constitutional authority and jurisdiction to assess those. Included in that are interprovincial pipelines. That's kind of a non-issue. And so if you were to reframe some of the political arguments from recent years, this wouldn't, and flowing from the majority's opinion yesterday, it wouldn't be the No More Pipelines Act. It might be the No More Hydro Dams Act, or no more in situ oil sands projects. It's that second class of what the court calls intra-provincial projects that are that the majority was preoccupied with. When it comes to interprovincial pipelines like TMX, there's really no debate. It's explicit in the Constitution, and even the majority of the opinion yesterday recognizes that.
Interesting. The second question I wanted to ask you about was the language in the majority decision. It was unusual, to say the least.
Yeah, that was perhaps one of the most surprising dimensions yesterday, although not entirely surprising. We all had quite clear tea leaves to read, if you will, if you look back on the Alberta Court of Appeals majority opinion, in the Greenhouse Gas Pollution Pricing Act reference case from a couple of years ago. That was sort of the first episode of this movie, also dealing with constitutional matters, also including this kind of fiery, colorful, tilting towards political language, which some have characterized as hyperbolic, and that's probably fair. So it went beyond what one might expect. Again, this isn't your standard everyday court decision. It's an opinion. It's a reference case. So that may offer some latitude. There's, not a lot of clarity on what the parameters might be, but certainly this was surprising. And I know at least one legal commentator noted that perhaps not all that helpful in our politically fraught context. it might more balanced language might be more appropriate. And indeed, when this goes to the Supreme Court of Canada, likely the Supreme Court of Canada will take the opportunity to provide a more balanced tone and a set of reasons.
Yeah, we'll be in big trouble if the Supreme Court of Canada's decision reads anything like the Alberta Court of Appeals majority decision. Well, look, let's get into the decision. So the majority decision characterized the act as a classic example of legislative creep. What did it mean?
Well, what the majority meant is provinces, of course, have jurisdiction flowing from a number of heads of power in the Constitution, including with respect to the extraction, development, and so on of natural resources. Now, that jurisdiction, of course, is not unfettered. And we're in a world where Canadian constitutional law has evolved to a point where all laws are presumed to be constitutionally valid. And to the extent that there's overlap and potential conflict between the laws, the courts are going to read those in the spirit of what's known as the principle of cooperative federalism. Now, the majority in yesterday's opinion steered away from some of that more nuanced constitutional law doctrine and really became preoccupied with provincial jurisdiction and kind of downplayed the degree to which the act actually has safeguards built into it to safeguard against that legislative creep. So while it may appear that way on at first blush and on first reading, there are a number of steps in the act that again, are checkpoints for the federal government to ensure that it's not exceeding its jurisdiction in deciding whether to approve a project, how to approve a project, how to assess the project, and so on.
So it looks like this is going to go to the Supreme Court. And you note that the existing doctrine is more closely aligned with the dissenting opinion from the appellate court.
Well, that's my view. So, and a number of others have said that. It's risky to say that because everything is unpredictable. And I mean, one of the key points, just to pivot for 1 second, Mark, and one of the key points here is that cases don't come along very often in this area of law. Once or twice a decade, you're going to get a case that gets up to these levels of court on, constitutionality of federal environmental assessment. So in a way, the more the better. So we're experiencing the short-term pain of uncertainty and political friction, but the long-term gain will be more clarity from the Supreme Court of Canada. And we'll see what happens when it gets there. Now, I did that sidebar, Markham, but I forgot your main question. Sorry.
Well, that the existing doctrine is more closely aligned with the appellate court's dissent, and which suggests that the Supreme Court will more likely side with against, I guess, the majority opinion.
Right. So where the minority dissent of one was alone yesterday, that voice will likely not be alone substantively at the Supreme Court of Canada. So what the minority did was really emphasize that this regime is less about intruding on provincial jurisdiction over natural resources and more safeguarding against adverse effects on areas of federal jurisdiction. And both levels of government are entitled constitutionally to engage in this realm, and it's a balancing act. And there has to be an appreciation and weight given to the federal authority to, again, safeguard against adverse impacts on areas of federal jurisdiction, whereas the majority perhaps took a very narrow reading of that latter dimension.
When might we expect this to be heard by the Supreme Court?
That is really difficult to predict. I hesitate to say anything, but I expect it will get its process moving fairly quickly. The federal government will file, if it hasn't filed already, to appeal. And from there, different organizations will likely apply to intervene, for example. So you have to get all the parties lined up procedurally. My guess is that will happen in the next 4 to 6 months. Then a hearing date will be set, maybe 2 to 4 months after that. So I think you'll have a hearing within a year would be my guess. And then after that, the decisions can take anywhere from 6 to 12 months. And as you saw with the Alberta Court of Appeal in this case, it was actually 15 months post-hearing that this decision came out. So it's difficult to predict. Finish line, probably between 1 and 2 years from now, likely between 1 year and 18 months from now would be my best guess.
And in the meantime, essentially nothing changes?
Well, it's a good question. I mean, as of today, nothing changes. So it's still the law of the land. If you're a proponent of a major project involved in the process right now, today is the same as 2 days ago. If you're preparing a project, an application or submission to the process, it's the same. I've been trying to think of, is there some kind of legislative action that the province could take to try to, take this a step further? And, it's hard to see how the provincial government can legislate over federal jurisdiction. It's just, that's the point of all this, is that can't really happen. One hypothetical that I've been thinking about is, if you're a proponent of a project unhappy with the process right now, might this give you a little bit of ammunition, or at least some arguments to challenge the constitutionality of the regime under which your project is being reviewed right now? There aren't any examples of projects across the country right now that really stand out on that front. There's, clearly areas of federal jurisdiction implicated, but you might see some emboldening of those types of parties and those types of arguments in this limbo period between now and when the Supreme Court of Canada speaks. That's all sort of lagging thinking. One would hope that there's sort of proactive cooperation with the regime, recognizing what's likely to come down the pike.
Well, David, as always, thank you for your insights.
No problem. Pleasure to be here. Thanks, Markham.